Good morning and welcome to Early Care Connection. I'm Izzy Greenberg. Today we have our resident panel of experts. Actually, Merrill Gay is not here this morning. He is on a plane to a conference. But we do have Ava Bermudez Zimmerman from Child Care for CT. Thank you to Louiselle for providing interpretation for us this morning. And a reminder to our community to use the chat for communication between the community or for technical difficulties, and to use the Q&A for questions for our panelists. And reminder, if you're using an AI note taker, I noticed you guys have really gotten better at this in the last 3 weeks, but if you're using an AI note taker, just please remember to delete the notifications out of the chat because it clogs them up at the beginning and at the 30-minute mark. Thank you so much for that. Okay, so today we have a jam-packed morning. We have a whole show on the paid sick leave changes. And so I want to, let's see, I know we have Senator Kushner who's going to be on to give some welcoming and a little bit of context. Ava, is she available yet or not quite yet?
I am searching the attendee list, so just bear with me. I'm looking for the names here.
At some point, Senator Kushner will be joining us, and that will be great because it's nice to hear from a legislator that side of things. But until then, let's just get started. We have Heidi Lane, who is an attorney and the director of the legal division at the Connecticut Department of Labor, and she'll be joining us this morning to really walk through the details so that everyone can understand, get up to speed, and figure out what the heck is going on here. So Ava, I think we'll get started with the presentation, and then Heidi, will it be okay with you if a few minutes in Senator Kushner just joins you? You won't have to stop your share or anything.
Oh, absolutely. We work closely with Senator Kushner on the law and changes.
Fantastic. Well, Heidi, welcome. Thank you so much for taking time this morning to help us with this. And you're welcome to start your presentation. I will share that presentation in the chat in English and Spanish for folks. And of course, we'll have the recording up within the next 24 hours with all of these files as well. Heidi, thank you. Go ahead.
All right. I'll share.
Okay, so if you could just change it to the big version under display settings.
Under display.
The top, yep. The way, yep.
No, you did that wrong. I've got to go the other way.
It's all right.
How is that?
No, it's still the smaller version. Let's see. We'll figure this out. If you want to stop the share and maybe just share the slideshow instead.
Okay.
We'll get this, and it's no problem. This happens every so often.
Sorry.
It is complicated. No worries.
Let me just display settings. Oh, that didn't work.
All right. Hit share. Let's see. I can't. You're in PowerPoint?
Yes, I am.
I'm going to pull it up on my screen so that I can walk you through it.
I apologize.
It is no problem, really. This stuff happens, and it's not every day that that you're doing this. So our community is happy to be patient here. So let's see. Let me try to see what I can do here. Oh, there you go. Okay, look. So let's see. Top right, I think that share, let's see, does that do it? No. File. I don't use PowerPoint either very often, so I'm sorry that I'm not more help. Slideshow, perfect. From beginning.
Senator Kushner's here, so I was trying to create her a panelist, but since we were having tech problems, I'm going to promote her.
That sounds great. And Heidi, you're great. You found it. Good. Leave it right there, and we'll have Senator Kushner just join very quickly before you get started. And our community is perfectly familiar with being patient with tech issues. We have these kinds of things, unfortunately, but it's just being human. Ava, I am not seeing her.
Likewise, she just texted me she's here, but I'm looking.
She may be joined under someone else's name,
That's his name,
unfortunately.
yeah.
Yeah. Okay, Heidi, why don't you get started while we figure it out? Oh, and you are muted.
Let me know when she's here.
There you go. You go ahead, and then we'll interrupt you.
All right. Good morning, everyone. I'm Heidi Lane from the Connecticut Department of Labor, and we are responsible for the implementation of the paid sick leave law. And we have been for many, many years. But these changes came in, and I just want to go over some of these changes just so you know what's in store for you folks. And so you folks are employers, or you work for an employer under the law. And beginning January 1, this new law covered employers with 25 or more full-time or part-time employees in Connecticut. And in January 1 of next year, it's for employers with 11 or more full-time and part-time employees. And then on the 1st of 2027, all employers with one or more full-time. So some of you may already be subject, some of you may be subject January 1st, or you may need to wait until January 1st, 2027. So what you do to determine if you're covered is you look at your payroll on 1/1. And if you have 25 or more employees on your payroll, you've been covered since 2025. And then you look on 1/1/26 if you have 11 or more. Now, if on 1/1/26 you have 10 employees, you're not covered until the following year. So it's whatever you have on your payroll on the beginning of the year. So there's one issue that we need to address, and that is a seasonal employee. And that's not, I know you might think that that means someone who just works, in the winter or something like that. No, it's an employee who works 120 days or less in any year. And that's work days, not calendar days. So that's a different type of individual. So if someone is hired to work less than 120 days in a year and ends up working more, then on day 121, that employee is entitled to what they should have accrued during the previous 120 days. So anyone who works 120 days or less is not covered by the paid sick leave law. But even if you hire them for from 120 days or less, they are, once they hit that 121, they are covered. So the best thing to do, the best practice is to keep track of the days, of the work days, and to see if they hit over 120. And if that's the case, then they can start using paid sick leave. If they stay 120 or under, they are not covered by the law. So just keep that in mind. That is the best practice. Now let's talk about reasons for the leave. The employee or family member is ill, injured, or has a health condition. They are looking to get a medical diagnosis or treatment, and it's mental or physical. Both are included. The employee or the family member is seeking preventative medical care. And you can also take time for a mental health wellness day. And this is something that I'll define a little bit later. And this is because of the pandemic. This is if the employer's place of business or school or place of care closes by order of a public official or due to a public health emergency, that time is also covered under the paid sick leave law. And a health authority or the employer or a family member, if they deem that the family member poses a risk or the employee poses a risk, that is also covered by the paid sick leave law. So those are all reasons for taking a leave under the paid sick leave law. Now, the other issue is if someone, an employee or the family member is a victim of domestic violence or sexual assault, and time off is needed for medical care, counseling, relocating, participating in judicial proceedings, the paid sick leave law covers that as well. Connecticut also has a leave due to family violence is also covered in another statute that we have, and it provides 12 days of unpaid leave for victims of family violence. And the 12 unpaid leaves are in addition to any other leave. So employers cannot require the employee to use those days at the same time with the paid sick leave. That is separate and apart, and it's unpaid. Mental Health Wellness Day. It's a day during which an employee attends to their emotional and psychological well-being in lieu of attending a regularly scheduled shift. We have said in the past that it does not have to be in an entire day. And we have received a little pushback from that. But that is our position right now. You can take it in hour increments. You can take it in 4-hour increments, what is needed. So Mental Health Wellness Day, it's just like a regular sick day. If you need a few hours, you take a few hours. And one question that we get from a lot of employers, the type of question is, so you mean that if my employee tells me they need to go to the beach for their mental health wellness day, I have to permit them? And the answer is yes. That's the point of a mental health wellness day. Now, in order to understand who's covered by this law, we need to go into some of the definitions. And those of you, well, it should be almost all of you who are covered by the Family and Medical Leave Act, you'll recognize some of these definitions. A family member is spouse, sibling, grandparent, grandchild, or an individual who is related to the employee by blood or by an affinity whose close association the employee can show to be equivalent to those family relationships. So that's very important. And it's also in the Family and Medical Leave Act. So we have received questions. So if my neighbor is similar to a sister or a brother, could I take time off for that person? And the answer is yes. As long as it's a close association that you can show is equivalent to that type of family relationship. When this first came out in the Family and Medical Leave Act, And this definition was in there, the affinity definition. People thought that there would be a lot of abuse of this, and we have never received a complaint on this in the number of years that it's been in effect. So employees are using this wisely, and employers are permitting it wisely. So that's a part of the family member that's really important to understand. A child is a biological, adopted, foster, stepchild, legal ward, or anyone who, if the employee stood in local parentis in place of the parent when that individual was a child. And the child can be of any age. Grandchild is also included, which is new for the paid sick leave law. Parent includes parent-in-law. It includes a parent is an individual who is now or previously stood in local parentis to the employee. Let's say my aunt took care of me when I was a child. Then she stood in place of the parent for me. I could take leave for her. And a sibling is brother or sister related to the employee by blood or marriage. So that would include a sister-in-law and brother-in-law. And a spouse is a person who's legally married, or there's a domestic partner. Common law would be included if their common law is recognized in a different state. Let's talk about the accrual. The paid sick time begins to accrue on the employee's first date of employment. If you're all of a sudden covered on January 1st, that is when they begin to accrue under this law. And the accrual is the rate of 1 hour of paid sick for every 30 hours worked. So, and it must be hours actually worked. And it doesn't include vacation time or anything like that. So if I work a 40-hour work week, I have earned 1 hour plus, because I earn the hour for 30 hours. And then the 10 hours goes into the next week. So it's every 30 hours. And that's how you keep track of the time. A year is any 365-day period that the employer uses to calculate employee benefits. If it's a calendar year, that's fine. If it's an anniversary date, that's fine. Now, there are some employees who are going to be exempt from overtime. So those are your salaried exempt. And those people, they are presumed to work 40 hours per week. But if they work over the 40, they don't accrue paid sick leave for any of those other hours. And if their normal work week is less than 40, then that's the basis on which they accrue.
So Heidi, I'm going to take that natural pause because we finally were able to troubleshoot and get Senator Kushner on. And apologies to all on the call. We just had some technical difficulties with me sending her panelist invite, but she is on.
Yes,
So
I
welcome, Senator. The floor is yours. And just to quickly introduce, as Heidi mentioned it, she was pivotal in making sure that this was written into law. So Senator Kushner is a big ally and friend to childcare and early care workers. Senator Kushner.
Well, thank you for inviting me, and I'm so glad, Heidi, to see you. I haven't seen you for a while. And I know Molly O'Connor, who works for the Senate Democrats, is on as well. And I really, it was a huge effort to pass a bill that would give every worker in Connecticut paid sick days. And of course, we did have to compromise and phase it in, but we're at the phase now where a lot of the people in this webinar will be covered by paid sick days. And, it's just something that I deeply believe in, that every worker needs to have the opportunity to stay home when they're sick and still not lose pay, because you can't pay your bills when you lose your pay. And particularly in this field, because when you're taking care of children, and if you go to work sick, then the next kid's going to get sick, and the next kid, and then it goes to the families, and it has a, really huge impact on everyone when people have to go to work sick. And so for me, it was a no-brainer. But it was hard to convince some of our legislative friends how important this was, and a lot because the business world was lobbying against it. Your field is particularly interesting because you are both employers and employees. And so I'm so glad Heidi is here to explain to you how this works in very detail. And I know it's a little complicated, but once you get used to it, I'm sure it will come as second nature. And of course, everyone benefits from this. People are happier at work. People go to work when they're feeling well, and the children benefit and the employers benefit as well. So it's really, oh, and I see Haley Zawolinsky is here. I'm going to have to get off. Haley's my aide, and we're always available to help troubleshoot if you need help with that. But DOL and Heidi and the people who work at the Department of Labor, they're really the ones that are making this, work smoothly and explaining to people. So I just wanted to say how grateful I am to everybody who works in this industry. It's one of the most important jobs that we have, taking care of children. Unfortunately, it's not always paid to reflect how important it is in our society. So it takes a special person who's willing to accept those conditions, and for the love of the work and the love of the children. And so I appreciate all of you, and I'm happy that we could do something at the legislative level that would help you. Of course, we had already done the paid family medical leave, which is a huge benefit to all of you, and raising the minimum wage, which had an impact on the industry. So we've really been working hard for many years now to make sure that the childcare industry, the early childhood education field, is recognized. And hopefully now with the with the endowment that we have that will lead us toward universal pre-K, will also be something that benefits you all in the future. So thank you for letting me have a few minutes of your time, and I'm going to sign off and let you get to work. But I appreciate all of you.
Thank you, Senator. And again, for anyone who just jumped on, Senator Kushner has been quite the ally for childcare. Like she mentioned, paid sick days, paid family leave, as well as any raises that you've gotten on Care for Kids. Senator Kushner is right there in the center. So thank you, Senator.
Thank you. Have a great time.
Thank you. The floor is back. The mic is back to you.
Thanks. Thanks, Senator. Good seeing you again. As I mentioned, we did work very closely with her, and you're right, she was absolutely instrumental. Okay, so an employer may begin to use the accrued hours after 120 days after their date of hire. So not to be confused with the seasonal employee 120 work days. This is a different 120. So if you hire someone, if you're subject to the law now, and you hired someone on October 1st, they have to work 120 days before they can use this time. And it's one-time requirement. As long as they're working for this same employer. Once they meet it, they never have to meet it again. Usage. So employers are required to allow employees to use accrued paid sick leave in 1 hour increments. And they're not entitled to use it in less than that unless the employer permits it. So there are some exceptions and some what do you call them? There are some jobs that only permit it in 4 hour increments, but that's not included for you folks. So I just want to talk about what happens if the employee does not use all of their 40 hours. But before I do that, I want to leap down to the bottom rectangle. And it says, in lieu of carryover, employers may front load the amount of paid sick leave that the employee would be entitled to. And they can do that at the beginning of the new year, whatever 365-day year they use. If the employer front loads the time, the 40 hours, then you do not have to worry about any carryover because you're always starting with the maximum 40 hours every year. Employees are entitled to accrue and use the maximum 40 hours, and an employer does not have to provide any more. Any hours that are accrued in the current year that are unused can be carried over into the next year. I want to give an example of that, and this is where Senator Kushner mentioned that there were some complicated parts to this. But once you get used to it, as she said, it really does make sense and it can flow. So here's an example. I have accrued 40 hours in 2025, but I've only used 30. So I can carry over 10 into 2026. But I still accrue in 2026. I still accrue the 40 hours in 2026. So let's say I use 20 hours of sick time in 2026. Now remember, I've used 30 and I've carried over 10 from the previous year. I need to use 20 hours. 10 of those hours are from 2025. And the other 10 are what I accrued from 2026. So the 10 hours that I carried over from 2025 are now gone because they only last for 1 year for the carryover. So I've gotten rid of those. So I have accrued 40 hours in 2026. I've used 10 from 2025 and I've used 10 from 2026. So what do I carry over into 2027? I carry over 30 hours. So that, I know it's a little complicated, but one thing you have to keep in mind is you accrue 40 and you can use 40, no more than that. So even though I carried over 10 hours from 2025, I am still accruing, and it may look like I have 50 hours in my bank, but I really don't. Because I can only accrue 40 and use 40 in any 1 year. The carryover is used in the second year. But if I didn't use the carryover, it wouldn't go to another year. So I know that that's a little confusing, but we can absolutely help you with that. Now, at the end, I have one thing I didn't add, I need to give you our website because we have a paid sick leave page that has all the forms you need. It has lots and lots of frequently asked questions, probably a couple of hundred, and people seem to think that they make sense, so I hope they do. So you can always check those out at the Connecticut Department of Labor's main page. You'll what you can do is if you go to our main page, which is I'll think of what our website is in a minute. But if you go there and then all you have to do is put in legal in the search, you'll get to the legal division page. And we have the connections to all the different types of leaves. So you'll see that there. And if you go to paid sick leave, you'll see all the questions and all the forms. Now, one thing that has come up with the paid sick, it's different from other laws that we have, like the FMLA and paid FMLA. If I need to use a sick day, I don't have to provide any documentation that shows that I'm taking the leave for a permitted purpose under the law. There are those reasons that I can take it, so I need to take it for those, but an employer cannot ask for anything in writing. If I call in and I say I need to take a paid sick leave day, I get the paid sick leave day. Now, what type of notice is required? The law does not require the employee to provide the employer advance notice of their need to use paid sick leave. If you wake up in the morning and you are sick, you just let the employer know that you will be out sick. Now, they still have a right to know, employers have a right to know what you are doing. So that day, so it's not as if you can just not call in. You do have to call in and you tell them that you are using a paid sick leave day. But if there's a policy that says you have to give advance notice of their need to use paid sick, that they cannot require if they're using a day under this law. So the employer, so the employee still has to follow giving the normal notice that if they're not going to be in, they need to call. But if the policy is that they have to call in 2 hours ahead of time, and they can't do this because you woke up and you're sick, you don't have to give that 2-hour notice, and you cannot be penalized for that. You do have to give notice as soon as practicable. So when you wake up, you start getting ready and you notice you're sick, as soon as you know that you're not able to go in, you have to let the employer know. So this is what employers have to do, and we have these notices on our website. Posters have to be in conspicuous and accessible areas. you have to give written notice to each employee no later than either 1/1/25 or the employee's first day of employment. And employers with remote employees can either send the posters by email or publish the posters on some sort of digital platform. Posters and sample notices, just go to our website. Everything is there for employers. And employees should read the questions as well. So how much do you get if you're taking a paid sick leave day? You get the normal hourly wage for that employee, or the minimum fair wage rate. So this really goes more for tipped workers, so you don't have to worry about that, but tipped workers would get the minimum fair wage rate. And we don't really need to go through any of that. Overtime and commissions are not part of the normal hourly wage. Now, if there is a break in service, whether voluntary or involuntary, if the worker is subsequently rehired, the employee loses all the accrued paid sick leave, but they retain the calendar days that they worked towards the 120 calendar days requirement. And then they begin to accrue sick leave again upon rehire. So if they've worked the 120 calendar days, they can immediately begin to accrue and use the paid sick leave. Okay, so employers that give I just brought some employers that give more leave than the 40 or gives a combination, that you're in compliance as long as you can use the paid leave for one of the reasons in the law. It's accrued in total at a rate equal to or greater than 1 hour for every 30 hours worked. And for 40 hours of that paid leave, the employer has to follow the notice and documentation parameters of the paid sick leave law. So let's say an employer gives 80 hours of PTO, and I need to use a few days for paid sick. If the employer's policy is that you have to give notice, and you have to give a note, if I am using the PTO for a reason under the paid sick leave law, the employer cannot require notice and cannot require documentation. Now, if you do have a plan that allows employees to accrue more than 40 hours of paid sick leave, they can limit the use of the additional hours over 40. So for the 40 hours, you have to follow the limitations and the parameters of the paid sick leave law. But for anything over the 40, employers can apply their normal attendance and time off policy. So at that point, when you hit the 41st hour, employers can require documentation before permitting the use of any hours over 40. They can follow their policy for anything over 40. Can the employer require employees to find a replacement? And the answer is no, they cannot. They're prohibited from requiring employees to find replacements before allowing them to use their accrued paid sick days. Collective bargaining, you still, changes can't diminish any rights already granted in a bargaining agreement. And, anything that, changes can't override the terms of a collective bargaining agreement unless they have been renegotiated after 2012. Record keeping. Please keep track of these records. It does not have to be on the pay stub. But you do have to keep track of it as part of your normal record keeping obligations. So records have to be conveniently, securely, and privately accessible to and printable by the employee. The same way it is for any wage and hour records that need to be kept by the employer for the employee. They have to be kept for at least 3 years. And we get access to those records when we have to monitor for compliance. And if you don't maintain and provide reasonable access, it's a violation of law, and there could be $100 civil penalty per violation. Now, this is but everyone keeps the records anyway, so I really don't think this is going to be an issue. You follow the laws for all the wage and hours records, so you do the same for the paid sick. So I don't think that that will be a big issue. No employer shall take retaliatory personnel action or discriminate if someone requests or uses the paid sick, files a complaint with us. And retaliatory personnel action means termination, suspension, demotion, anything, any adverse employment action. Now, what's interesting so far is there have been very few complaints that have come in. They come into our Wage and Workplace Standards Division, and we have been able to, our wage agents have been able to work everything out with the employee and the employer, and they have not had to take any formal action. They just try and work everything out. Because this law is complicated, that's what we try and do first. Just try and make sure that everyone understands the law and is doing everything that they need to do under the law. Now, for Wage and Workplace Standards Division, they're the ones that handle paid sick. They do all wage and hour. They also have a website on our, and you can put that in the search. For the legal division, we have a specific dedicated mailbox for legal questions, and you can ask paid sick leave questions there if you want. We also have, this is just so you know this, we also have a dedicated mailbox for FMLA as well. We also have a dedicated phone number for FMLA, which I forgot to put down, and it's 263-6400. So we have some, the number that I have there, the 6755, that's the general number for the legal division. And if you tell them what you need, we always have attorneys available to take questions and answer and give the guidance that you need for, well, pretty much any law within our jurisdiction, within the Department of Labor's jurisdiction. And you can also go to Wage and Workplace Standards Division and look at their website, because they have a lot of good information there as well. Now, that is what I have for the slideshow.
We've got some questions. So as you can see, Heidi, it's a jam-packed meeting today. So a lot of people, I think, between the morning hearing the slide deck, 300, and right now we've got some questions. If you're okay, can I kick us off with some questions?
Sure, please do.
Okay.
And also, just so you know, what I will do if we don't get to all of these questions, we'll do what we normally do, and that is, I will put them in writing, and I'll put the answers in writing and get them to Ava, and they can be distributed.
We appreciate you. Thank you. So we have here Anonymous. Anonymous is saying, if I am starting this January, it is 120 days for all my employees before they can use their time, correct?
Okay, where is that? Where is
And
that?
then the Q&A. So if you look at your toolbox, the Q&A, I'm just going chronological order.
Okay.
It's the question from 9:58 a.m.
Because I have a few before then. Oh, okay. Well, this is a really good question, and this is something that we explain in our FAQs. So if you're starting in January, you already have people who have worked 120 days. So take a look. So we believe that because they've worked, they should be able to start accruing on 1/1/26. So because they've already worked 120 days for you, if they have. If they haven't, then they need to continue on.
Okay. Okay. So hopefully folks understand, if they haven't accrued those 120, they keep working. The second question here, Melissa Newman. Thank you, Melissa, for your question, as well as Anonymous. Are we required to carry the hours to the next year, or is that optional? So are we required to carry hours next year, or is carrying any hours optional?
It's not optional. You must carry over the hours unless you front load, because that way you don't have to worry. Or if you give an option, and it has to be an option to be paid out for those hours that you haven't used, you can do that too. But the law says you have to carry over. So you carry over. There's no way around that unless you offer a payout and someone takes it, or you front load.
Okay, awesome. Martha Wiley would like to know, does it have to be January 1st calendar date, or are we able to use a school calendar year? So when we're talking about those January 1st dates, is it calendar, or can we go into school, considering we're talking about educators here?
Yep. Okay, this is what makes this a little difficult, and that is the law itself says that you have to begin 1/1/26 for those who are just coming into being covered. So people would need to accrue that time, but then you can switch over to your school calendar year when you hit August or September. It's the first year is going to be tricky, and please feel free to call us if you need some help trying to figure out how much someone accrues and when they can use it and all of that. But you will be able to, after 1/1/26, be able to switch over to the year.
Make it easier.
Yes.
Awesome. So directors out there, owner operators out there, once you get on a schedule and alignment with the rules, past that year, then whatever schedule you have, go with it. Awesome. That does make their lives a lot easier. Mary Chicanato. Mary came in late. No worries, Mary. Everyone here is busy working right now in live time. So we appreciate your question. if you already give days off, do you still need to give the 120 hours above what you already do?
Okay, it's not 120 hours. If you already give time off, remember the 120 hours is just to be eligible to take paid sick leave. So that's so forget the 120 days when someone meets that. So if you give 40 or more hours and they can use it for a reason in the law, and you don't require documentation, you don't require notice, and they can take the time off and there's no penalty, then that you don't need a separate bucket. You can use what you already give and use that as a PTO bucket, a paid sick leave bucket. And as long as they can use up to 40 hours for a reason in the law, you're in compliance.
Yeah. Anonymous would like to know, just a point of clarity, the part-time employees are gaining or half, well, let me just read the question like it says. Okay. Full-time employees earn a week of sick time per year, and half-time employees earn 2 weeks of sick time per year, question mark.
Not full-time will undoubtedly earn 40 hours. Wait a minute, are you saying that you give them that?
Check out Q&A 10:10 a.m. So the question said exactly, so full-time employees earn, and it's
Okay,
as a question, right? So I'm assuming they're asking part-time versus
Okay.
half-time, full-time versus part-time.
so part-time they're going to accrue, remember, they accrue 1 hour for every 30 worked. They're gonna earn probably less than 40. They don't, because it's hours actually worked. The 30 hours are
Regardless if they're full-time or part-time.
right.
Okay,
So it'll just take the part-timer a longer time to accrue
longer.
time.
Okay. So just it's about hours. Employee can be part-time, full-time, 20 hours, 40 hours, 50 hours. It's about hours.
Exactly right.
Okay. Carol would like to know, what is the website for these forms? And I think you had it on the slide deck, and we could also,
Um,
or was it just your contact information on the deck?
yeah, it's our website, the Connecticut Department of Labor website, which you would think I would know by heart.
No worries. I'll go ahead while you answer some questions. I'll go ahead and put it into the chat. So Carol and anyone else looking for it, I'll go, just give me like 2 seconds, and while Heidi's answering some questions, and I'll put it in the chat for everyone.
Thank you.
Thank you. Edie would like to know, what if someone says they need more than one mental health day at the beach, like 3 in a row? We have ratios we need to meet. Centers could have to close classrooms if we don't have coverage. Parents would be very upset. So I guess the question is, if someone is not so, if someone has legit mental health days that they want, and they're doing it consecutively and they have it accrued, do employers have to give it?
Yes, they do. And this is what is a huge problem for people like you folks who need to have coverage. And this is part of the law that does make it difficult. And we've heard this from many other fields as well, occupations as well. But the thing is, if someone is calling in with paid sick, whether it's a mental health day or not, we know that that's going to cause some difficulty, but they're still permitted to take the time. Could someone take 3 mental health days in a row? Yes, but it's all within the 40 hours that are permitted under the law. Someone doesn't even have to tell you that it's a mental health day. They could just say, I'm calling out sick. And that is that's going to be difficult for employers as we know that intermittent FMLA can be for centers as well, but it's what's written into the law.
Okay, fair enough. Heidi, just to make sure I'm giving the correct website here, I'm just looking it up. I saw frequently asked questions that I just put in from ct.gov,
Yes,
and the forms, you said it's just in the Department of Labor?
yes. It should be same page with the FAQs and if you on our homepage, www.ct.gov/DOL. Ah, that just came to me. ct.gov/DOL.
Okay, so I'm just going to put that in right now, and
Thank
then I
you.
see that
Hope it
there's
works.
FAQs and
Perfect.
okay.
And if you go to if you just put in paid sick leave in the search or legal division in the search,
It
you'll
pops
see a
up.
page that has everything. So thank you
Yeah.
for putting
And
that.
I just verified I closed out everything and I went to the website, and it also allows you for our Spanish speakers to change, or Arabic speakers to change the language as well. So if you're in need of switching out languages to see all these documents, the FAQs, just pick the language of your choice and it immediately does it. Okay, going back to questions. Wow, we might not get to all. We have like 2 more minutes. I'll take
Take it
3 more
easy.
questions here because there's a bunch. Pam, if you front load and someone leaves employment having taken hours that they wouldn't have accrued yet, can you charge back those hours they haven't earned?
Good question. And but not if you front load. Because you're by front loading, you're giving them the time. So essentially they have accrued those. Because that's what you're giving them. If you if someone needs an advance, that's a different thing. But when you front load, you cannot get it back.
Okay.
Oh, someone wanted to know what front load is.
Oh, good question.
Yeah. So front loading is just giving someone the 40 hours or whatever it is that they would have accrued, but giving it at the top of whatever year you're using. So you don't have to worry about carryover. They're getting a brand new 40-hour entitlement every year. That's a front load. So you don't have to worry about anything. You give it to them and you let them take it and you're done for the year.
Okay. There's about 3 questions that are follow-ups to original questions from Edie, Deborah. I think this anonymous is also a follow-up. Can they be denied payout at the end of the year?
And they'd be denied payout at the end of the year. Payout of the paid sick, because they don't.
I'm assuming payout of the paid sick, yeah.
Yeah, you don't pay out at the end of the year. You don't have to. You can carry over or you can front load, but paying out is totally at the employer's option. And it's also an option for the employee, whether they want the payout or they want to carry over. So there's no requirement for payout. And there's also no requirement to pay any unused paid sick leave when someone terminates from the employment, unless it's in your policy that says they do pay it out.
Okay, and Cherie, I believe we just answered it. Cherie had a very similar question about what is front loading, which you just answered, Heidi. Cherie also wanted to know, does it restart? And then you also answered that earlier that, once you're a year in and you've accrued and you've gotten your accrued, you have your hours. So you did explain that. And then Deborah follow-up so part-time employees who do not work 40 hours are given 40 hours or they can receive their week's worth. I think, Heidi, you said that part-time, full-time, it doesn't matter. It's all about when they reach that accrual, correct?
Right, 1 hour for every 30 worked, so a part-time may not accrue 40. They may accrue 30 during a year.
And then another follow-up, Edie said, so we give 15 sick days per year with 10 that carry over. Most of my staff have 25 days each year with carryover. How does it work?
You're in compliance. As
Okay.
long as for 40 of those, you don't require a note, don't require documentation, but you are totally in compliance with that amount of time that you give.
And is there a maximum you can roll over?
There's no max as far as we are concerned.
Okay.
As long as someone gets the 40 hours and you do that and more, do what you want.
Okay, so Amy, there's no max. It depends on you. I'm going to take one last question here. Well, really quickly, anonymous. If you're wondering if your job is protected with paid sick leave, that is another program. We are talking about paid sick days. For paid sick leave, that program doesn't automatically protect your job. It's through FMLA. So Connecticut Paid Leave Program or federal FMLA does protect your job. But if your employee is applying through the paid days, it doesn't mean that it's protected through that application. It's protected through the federal and Connecticut program. I know that sounds convoluted, but it's technical. I serve on the paid sick leave board, and one program is the application process where the employee gets paid out. And then another program gives you the legal protection to not lose your job as long as you qualify for the different reasons you're taking that leave. So if your employees fall under sickness, caring for an elderly, surgery, birth, caretaking, if it falls under those categories, which you can check out, then and authorized, then yes, they are protected. And then the paid leave program pays them for that time. But go ahead, Heidi.
One thing, and this is because all of these names of these programs are too close.
Yeah, that's accurate.
So I just want to, so there's CTFMLA, there's federal FMLA, there's Connecticut Paid Leave, and that's the program that Ava was just talking about. And then anytime you see paid sick leave, that's going to fall under the paid sick leave law. So that's why it gets so confusing. We should talk to Julie about this. The name. Paid sick leave is 40 hours and it's protected time. Job protected. And as Ava said, the Connecticut Paid Leave law is not protected, but you get paid for FMLA. And then there's Connecticut FMLA, which is job protected.
Yeah.
It's so confusing, and there are so many similar names. But what we call paid sick is all of this law.
Yes, we are over time, and there's just a handful of questions. Heidi, if you feel comfortable staying on and typing in answers for those questions, then great. If not, then I will definitely send you the questions that we have here, and you can respond, and we'll post it on our YouTube channel and our website. But thank you so much for your time, and this was nuance.
It is. And would you mind sending them to me?
I will, no problem. And we promise everyone who we didn't get to your questions, so sorry. We're going to send them to Heidi. We will always post those questions and answers in our website as well as a YouTube channel. So if we missed you right now, you're not missed forever. Thank you, everyone, for chiming in and for the vibrant conversation. Thank you, Lucelle, for your interpretation. Have a wonderful rest of your day, everyone.
Thanks. Thanks, everyone.